Hello, everybody, and welcome to today's webinar on managing sickness absence. It's a popular topic, judging by the numbers that have dialed in, so no pressure for me and Simi then. So first of all, I am Sarah Wilkinson, and I'm a Senior Associate in the Labour and Employment team in our Birmingham office. And I'm being accompanied today by Simi Bassi, who is an Associate also in the Birmingham office. The aim of today's session is to give you all advice on the legal and practical issues to consider when managing employees who take absences from work due to ill health. We'll cover short-term absences first, and then spend a bit more time discussing how to handle long-term absences, as we do find that those are the issues that employers struggle with the most. As we go through, we will flag typical mistakes made by managers and how these can be avoided. We will also discuss disability-related absences and the additional issues employers should be aware of when handling such absences.
Okay, so why is this important for employers? Absence management has always been an important issue for employers, but it's even more important now with sickness absence levels at a record high in the UK. According to the CIPD, as at October 23, the average rate of employee absence was 7.8 days per year, the highest rate in a decade. Similar data has been published by the Office for National Statistics. This means increased costs for employers, not only in the form of sick pay costs and the cost of arranging cover, but also because absence, however genuine, causes operational difficulties, can undermine quality and customer service and places an additional work burden on other employees. So why are sickness absence levels so high? Now, as you would expect, there are a number of reasons why sickness absence levels are so high at the moment. More employees are off work due to delays in NHS treatment as waiting lists have got longer, the impact of austerity, and increased workplace stress. We are also dealing with the long-term effects of the pandemic, with over 700,000 people having been signed off sick since the pandemic. The focus of today's session is on how to manage sickness absence in the workplace, but clearly a key issue for employers is reducing sickness absence levels in the first place, and there are various steps an employer can take to try and achieve this. Sickness absence is also a key focus for policymakers, and the new Labour government has said that one of its priorities is to reduce the cost of economic activity due to sickness absence. It was only last month, for example, that they announced a new free health check programme to certain workplaces across the country aimed at preventing certain conditions. We expect further developments at some point, and we will of course keep you updated of those. Okay, so before we get into the mechanics of handling short and long-term sickness absences, it's worth reminding ourselves of what an employment tribunal will expect to see if a dismissal for sickness absence does end up in the tribunal. At a very simple level, as per the slide, from an unfair dismissal perspective, a fair reason and fair procedure should equal a fair decision. Sometimes it can be difficult to establish the appropriate reason for dismissal, particularly in the case of short-term intermittent absences, as they don't always fit squarely with either capability or conduct. After all, if an otherwise fit employee has a number of sporadic certified absences but continually returns to work, they can't really be said to be incapable of doing the job for which they're employed. The courts have, however, accepted that dismissals on grounds of short-term persistent absence can be fair, and they usually fall within the catch-all category of some other substantial reason, so SOSR. Now, although ill health might have led to the absences, the reason for dismissal is that the employee's attendance record did not meet the employer's required attendance standards, which are usually set out in an absence management or attendance procedure. When it comes to long-term sickness absence, which is usually defined as sickness absence lasting for at least 4 weeks, an employer might define it differently in its own policies and procedures, but capability will usually be the potentially fair reason for dismissal. Capability in relation to an employee means their capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. So it would cover things such as long-term sickness absence. In unfair dismissal cases, the burden of proof will be on the employer to establish that the reason for dismissal was capability or SOSR. Once that has been established, a tribunal will consider whether the employer acted reasonably in treating that reason as a sufficient reason to dismiss the employee, having regard to equity and the substantial merits of the case. In considering the question of reasonableness, the tribunal will consider whether the decision to dismiss fell within the band of reasonable responses of a reasonable employer. So, all very reasonable. The test is not therefore whether the tribunal considers the decision to be reasonable, but whether it was reasonable, bearing in mind the fact that other employers might reasonably react in different ways to the same situation. A fair process is essential if you want to be able to demonstrate a fair dismissal. In terms of establishing a fair process, there are a few key points to be aware of when handling sickness absence. So first and foremost, your own policies and procedures. Many large employers, which will include most of the people on this call, will have policies and procedures in place for dealing with sickness absence, whether that's short or long term, and it's obviously important that the employer seeks to comply with its own policies and procedures, so far as the circumstances permit, even though the policies should not be contractual. Having policies and procedures in place helps to ensure that managers deal with employees fairly and consistently. So whilst a failure to comply with your own policies will not automatically render the dismissal unfair, a tribunal will take into account any failure when determining the fairness of the dismissal, so it's important to get it right. Now just a quick word about the statutory ACAS Code of Practice on disciplinary and grievance procedures. Now, as we're probably aware, the code only applies in disciplinary and grievance situations, so it's not applicable in the case of sickness absence dismissals. There is, however, case law which confirms that the ACAS code will only apply to ill health cases where there has been culpable conduct, i.e. poor performance or misconduct. This means that a failure to comply with the code will not lead to an uplift in any compensation award. The non-statutory ACAS guidance that accompanies the code does include a section on managing absence, and there is also other ACAS guidance available on managing sickness absence, which is worth having a look at. But of course, it's always still important to follow a fair process. We'll talk about what that should involve shortly. There is also a huge body of case law on unfair dismissals and what does and does not constitute a fair dismissal. Tribunals will look to that previous case law when deciding whether a decision is fair or unfair. And finally, employers should be aware of the requirements of the Equality Act 2010 when making any decisions that affect someone who may be disabled as defined by the Act. Again, we'll talk about this a little bit more later on. Okay, so just moving on to managing short-term sickness absence. Managing employees who take frequent short-term absences from work due to ill health can be both difficult and frustrating, as such absences can be incredibly disruptive. When dealing with a short-term sickness absence, a fair process involves a number of steps. Firstly, we need to ensure that the employee is aware of standards expected of them. So it's important that they're aware of what's required of them and the impact the absence has on the business. They should also be aware of how the employer will handle any absences from work. For example, in accordance with any attendance policies, any procedures. This will include reporting sickness absence, the provision of evidence of incapacity, and the requirement to attend return to work interviews. We should then look to provide the employee with sufficient warning. So employees should be made aware if their level of absence is unacceptable. Most attendance policies do provide that if sickness absence exceeds certain trigger points, then the company will take formal action under the procedure. This will usually involve holding formal absence reviews, interviews with the employee, and where appropriate, issuing formal warnings. Any warnings should clearly state that the employee's current level of absence is unacceptable, that their attendance record needs to improve to a stated acceptable level, how and in what period of time their attendance must improve, any support that the employer will provide to assist the employee with improving their attendance. It should include the date of any future review meeting to discuss their attendance record and what the consequences of no improvement will be. It should also be made clear to the employee that ultimately, if their attendance record does not improve despite the warnings and being given the opportunity to improve, then their employment may be terminated. I think now is a good time to flag that any pregnancy-related sickness absence before the employee goes on maternity leave should not be taken into account when managing attendance. We'll come on to discuss disability-related absences shortly. Now, what do we do if there's only a slight improvement? Ideally, the attendance policy will make it clear that warnings can be extended for a long period of time, thus extending the period of time during which the attendance record must improve. Alternatively, the company may say that if the employee's absence record drops below acceptable standards at any point in the future, then it can rely upon the past warnings when considering what further action to take. So, in other words, you don't have to start from scratch. In certain circumstances, it may be appropriate to request medical evidence, and this will depend on the reasons for the employee's absence. It may include referring the employee to a company doctor or occupational health professional, or obtaining further information from the employee's own GP to determine if they have an underlying medical condition or whether they have a disability. This may not necessarily be the case if absences are for something straightforward and unrelated, but if there is a possibility the employee may be suffering from an underlying condition, then the employer should consider obtaining advice about the nature of any illness. This will include the likelihood of any future absences as well. It may be appropriate to do so before issuing any warnings under the procedure or before taking any decision to dismiss if their attendance has not improved. We'll come on to discuss shortly the additional issues for employers to consider if the employee may be disabled for the purposes of the Equality Act. The employer should also consider alternatives, including alternative employment. Ultimately, if an employee's attendance does not improve following a series of warnings, the employer will have to consider dismissal. But before taking this decision, the employer should clearly meet with the employee and give them an opportunity to present their case, as you would in any dismissal situation. In making your decision, the employer should take into consideration factors such as the nature of the employee's role, the impact their absence is having on the business, the opportunity the employee has been given to improve their performance, and any up-to-date medical evidence. You should also consider whether an employee may be offered a different role, even in cases of short-term absenteeism caused by sickness. And ultimately, if you do go through these steps, any decision to dismiss should be found to be fair, should it ever end up in an employment tribunal, that can be subject to keeping a proper and full paper trail. So do not forget the importance of keeping a paper trail so that you can evidence the steps you've taken to manage the employee's absence. It sounds obvious, but this is something that's frequently overlooked, and it can then be hard for employers to defend claims if they do end up in tribunal, despite having taken all the correct steps. Handling employees who are off on sickness can be a lengthy process, and it's easy to lose track of what steps have been taken to deal with the employee. So detailed records of meetings with the employee and details of medical reports obtained are all useful if the employee brings a complaint in the tribunal. A lack of decent paperwork is one of the most common mistakes employers will make when managing employees on sick leave. So a word of caution. I'll just hand over to Sarah, who will discuss long-term sickness absence.
Thanks, Simi. So, as with short-term sickness absence, employees should manage any long-term sickness absence in accordance with their own absence policies, so far as circumstances permit. Even though the policy should not be contractual, and we would hope that your policies aren't contractual in that respect, it should provide you with a really good, clear roadmap to ensure a fair and thorough process is carried out. So, in our experience, one of the most common problems we come across is that managers frequently fail to keep in regular contact with employees who go off on long-term sick leave. Unless under doctor's orders not to retain contact, this is likely to result in any subsequent dismissal being held to be procedurally unfair. And I appreciate it can be really difficult to have those kind of conversations with employees. And even if an employee is absent with, say, mental health issues, which makes it more difficult and a bit more uncomfortable possibly for the manager, it's still important for an employer to make contact with them, and they have to make efforts to sort of keep in touch. Now, there's a case, East Lindsey District Council in Albany, and there was some really useful guidance there, and it said that discussion and consultation with an employee on sickness absence, long-term sickness absence, is essential because, one, it will often bring to light facts and circumstances of which the employer was unaware, which will throw new light on the problem. If you're not talking to your employee, how do you know what is happening? The employee may wish to obtain their own medical evidence, which may result in the employer's medical advisors changing their opinion. Again, if you're not talking to the employee, you don't know what appointments they might have coming up, what consultant they're going to see, and what medical evidence that they have. And then finally, an injustice may be done if an employee is not consulted and given an opportunity to state their case. And it's also important, I think, to keep in touch with an employee from an employee relations perspective, because they are more likely to return to work if their employer has retained contact with them during any period of sickness absence. It sends a message that the business wants them to come back and that it cares, and that's important. Any such discussions should commence at the start of the absence and continue regularly throughout. Clearly, at the start of the absence, you may not know that it's going to turn into a long-term absence. That is why all managers should get into the habit of making sure that they do contact employees who go on sickness absence. As part of those discussions, consideration should be given to the employee's opinions on their condition. And when you are at the stage of looking at a potential dismissal, have a discussion about alternatives to that dismissal and try to do that at an early stage if possible. We're often asked, what do we do if an employee does not stay in touch? And hopefully your policy should make it very clear that employees are required to maintain reasonable contact with their line manager during any periods of sickness. And if they don't, they should be expected to be contacted by the company, which then gives you the ability to be able to sort of get in touch with those employees. Ideally, the policy should also make it clear that a failure to do so may result in company sick pay being withheld. This can often sort of help encourage employees to stay in touch, and it does manage their expectations. If an employee does feel that they are unable to speak to the company because of their illness, and that can often happen when somebody is off with mental health issues, an employer should look at alternative ways of keeping in contact with them. So would it be better to do it via email? Can you have a spouse or a partner as a point of contact? And if it is a manager, if it is the individual's line manager that an employee is saying is triggering the stress, so they don't want contact from them, think about who else in the business would be appropriate to maintain that contact. You shouldn't just sort of let it lie without having any kind of means of communication, because it will limit the information that you are able to get from the individual. Ultimately, however, if an employee refuses to contact the company and refuses to engage, it should be made clear to them what the consequences of that failure to cooperate will be, i.e. their employment could be terminated. But do be careful if you go down that route, because you need to be very clear on the basis on which you are terminating the employment. Is it on the grounds of misconduct because they are failing to follow a reasonable management instruction, or is it on the grounds of capability? I would exercise caution if you are looking at misconduct, because that is quite an extreme reaction if somebody may have missed one occupational health appointment. So do be very careful if that is the avenue you wish to explore. As part of that sort of process and keeping in touch, you should also be obtaining up-to-date and relevant medical information, and that's key when managing employees who are absent from work on long-term sickness absence. A common mistake we see from managers is failing to obtain appropriate medical advice or relying on out-of-date medical reports. I mean, I can't tell you how many times I've had clients come to me and say, right, someone's been off for 8 months. We wanted to dismiss them now. So I say, well, let's look at all the information we have. Let's look at everything. And they're relying on a medical report from 7 months ago, when at the time they were fully following that policy, making sure they got their medical evidence, and then they let it slide. You can't rely on an OH report or a GP report that's sort of 7, 8, 9 months out of date, or 6 months out of date. Things change, and you need to ensure that any decisions you make are made on a current medical report as far as you're able to get one. And you can look at getting them from various sources. So it could be from the OH advisor, it could also be from the employee's own GP, a company doctor, or a specialist consultant. If you do know that somebody's under a specialist consultant, do always try to get a report from them. They understand the condition, they will be able to answer your questions, and do make sure the questions you ask are appropriate. The next thing to kind of consider is any adjustments that you could make to enable a return to work, because a failure to be seen to consider appropriate adjustments to facilitate a return to work is another common mistake when managing employees who are on long-term sick leave. If, for example, a doctor says an employee may be fit to return to work provided certain adjustments are made, an employer is not bound to follow those suggestions, but they should be considered carefully and they should not be dismissed out of hand. Now, I'm just going to quickly, I had a question which is relevant here actually, that's just come up on the Q&A, which asked, well, if we have somebody who says they can only work from home because maybe they, traveling into work causes an issue or whatever that may be, but their job is not suitable to work from home, then that is an adjustment that you don't need to put in place, but you should consider it and be very clear as to why that job is not possible to be done from home. Is there anything else that could be considered? Just having a blanket policy of we don't let people work from home will not be sufficient. You need to look at the circumstances and consider whether that's an adjustment for that individual to be able to work from home. If, for example, they are, I don't know, work in a shop, then obviously they can't work from home. So then you look, are there any alternatives? If there are not, then you might need to consider dismissal. So hopefully that answers your question. So do consider any adjustments that are sort of suggested, as well as the GP or the doctor's suggestion, but consider what else you could do as a business. But remember, if it's not suitable for the job, you're not expected to implement them if they just wouldn't work. Do seek the input from occupational health. I'm sure many of you on here have had a mixed bag of results with occupational health, and it can be a bit potluck as to how good that report is, because sometimes it feels like they're just mirroring what the employee had said. but that in itself is useful if you know what the employer is saying. But occupational health reports are important because they will understand the workplace. And if you have that in conjunction with other medical evidence, so a doctor's report or a consultant's report, as well as the employee's own view, that should help you to get into the position that you need to get into in terms of the next steps. So you also do need to be very careful and consider whether an employee is disabled under the Equality Act, because there are certain obligations then in terms of making reasonable adjustments. For example, and there's another case, I do love a bit of case law, London Borough of Hillingdon and Morgan, and this is a case back in the 90s, which is still good law, and it held that an employer's failure to allow an employee who had become disabled to work part-time from home on a temporary basis to assist her transition back to full-time employment meant that it had also failed to comply with the duty to make reasonable adjustments. It held that in light of the size of the employee's organisation, it could have provided the employee with a gradual reintroduction to work over a couple of months to facilitate her return to full-time work. A phased return is one of the most common adjustments, and it is usually quite easy to do. If an employer is unable to do that, there needs to have very clear reasons as to why that is the case. And as I said earlier, just a blanket, we don't do that, or a blanket, you can't work from home, that will give rise to issues, and it's likely to give rise to a disability discrimination claim if there's just a blanket policy and you're not prepared to sort of look past that. You should also consider alternatives to sort of dismissal and what else you can look at. If an employee is unable to return to their existing position, consider alternative employment. Is there anything that they can do, even if adjustments is required to that role, but is there something that they are physically able to do, physically and mentally able to do? And even if the employee is not disabled within the meaning of the Equality Act, so the duty to make reasonable adjustments does not arise, it is still appropriate for an employer to consider alternatives to dismissal, so that a finding of unfair dismissal is avoided. Dismissal should be a last resort, so you need to look at adjustments, you need to look at alternatives, and if neither of those work, you can then move to the dismissal part of the process. In certain circumstances, an employee may be entitled to early retirement on grounds of ill health. Whether or not an employee is entitled to such a benefit is normally governed by the terms of the pension scheme, and it's usually necessary for a doctor to recommend the employee for early retirement. So that might be something you want to look into on a case-by-case basis. Also, if the company operates a permanent health insurance scheme, that might make the employee sort of someone else's problem for the duration of their ill health. Someone else can deal with the payment of their salary. But if there is such a scheme, any dismissal would have the effect of denying the employee any actual or contingent rights to benefit. And so then any dismissal is likely to be a breach of contract because you are denying them those rights. And that would entitle them to claim against the employer for the benefits lost under the scheme, which can be really expensive. We don't see PHI schemes as often anymore for that reason, because it can make it very difficult to dismiss. If you are in that position, I would, and I'm not touting for work, I promise, but I would suggest that you seek legal advice to see what you can do in those circumstances. If your contracts are right and your policies are all correct, you should be able to be in a position where you can dismiss safely. But because of the potential cost around a dismissal, if you have a PHI scheme, you should look at looking for some legal advice. As Simi's already mentioned, do keep records. Handling employees who are off on long-term sick can be a really lengthy process. And, you know, I'm dealing with a client at the moment, someone's been off sick for 2 years, and it's very complex. And various HR people have left in the meantime. So there's a little bit of documentation having been lost, etc. So make sure that there is, you know, you kept track of all the documents, you know what meetings have happened. And remember, any of those documents, meeting notes, letters, are disclosable as part of a tribunal, could also be disclosable as part of a data subject access request. So make sure those records are complete and accurate and they don't get you into any trouble. So Yeah, it's one thing saying you've taken all necessary steps to assist an employee, and it can be quite another thing to prove it. So do make sure your records are complete. So let's go on to the next slide. Disability related absences. So employers do need to take additional care if an employee has a disability or if it suspects that there might be a disability. And some of those absences, whether they're long or short term, are disability related. We've already talked about the importance of obtaining medical evidence. And actually, whether somebody is disabled for the purposes of the Equality Act is a legal issue, which always seems a bit odd. But medical evidence obviously plays a part in that, and it's an important role in determining whether someone is disabled for the purposes of the Equality Act. So on the slide, it does set out what the legal definition is. And it is a person is disabled if they have a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So if we take short-term absences first, if your medical advice states that the employee is or is likely to be disabled, then you should consider whether it would be appropriate to exclude any disability-related absences when reviewing an employee's attendance record and deciding whether to issue a warning under the attendance procedure. This is because the courts have made it clear that employers should have regard to the duty to make reasonable adjustments when issuing warnings to disabled employees for sickness absence. This doesn't mean that employers are automatically obliged to remove warnings or discount any future disability-related absences. The factors that will need, which are relevant in reaching a decision as to how to deal with it, will include the nature of the employee's disability, the impact this has on their attendance, the length of their previous disability-related absences, and the likely length of future absences. The effect the absences are having on the business, whether an extension of the trigger point in which you would be issuing a warning would remove that disadvantage, whether the medical evidence suggests there may be an improvement in the employee's condition. For example, does the employee's depression mean that they are likely to have a lot of future absence, or does the fact that they are now receiving treatment mean that their attendance record is likely to improve? If the disability-related absences are discounted, they should still be recorded on the employee's file, and managers should still carry out return to work discussions, etc. And a decision to discount disability-related absences should also be kept under review, and that should be made clear to the employee as well. So they know that this isn't just a given, it's not always going to happen. It should be kept under review at all times. I'm going to, as I said, I do love a bit of case law, and there is quite an interesting case, I think, which sort of illustrates what the obligation is really. And it's Griffiths and the Secretary of State for Work and Pensions, and this was in 2015. So the employee worked for the DWP for 35 years. She was absent from work for 62 days, and she returned to work, and she was found to be suffering from a disability. The formal attendance management policy was activated in this case when an employee reached the consideration point, as it was called in their policy, and that was 8 working days absence in any rolling 12-month period. And the policy did say that consideration will be taken, the consideration point would be extended as a reasonable adjustment for disabled employees, and disability-related absences could also be ignored in exceptional circumstances. This employee had obviously reached that trigger point because she'd had 62 days absence and there was no extension granted in view of her disability. So she started to use annual leave entitlement to cover her sickness absence. She raised a grievance, it wasn't upheld. She brought a tribunal claim for failure to make reasonable adjustments. She said that the DWP should have discounted her 62-day disability-related absence and withdrawn the warning, and it should have modified its attendance management policy to allow her in future to have longer periods of absence before she faced the risk of sanctions. This went all the way to the Court of Appeal, and the Court of Appeal said that there was a policy in place which required employees to maintain a certain level of attendance at work in order not to be subject to the risk of disciplinary sanctions. that is quite a common policy that employers will have in place. And the Court of Appeal said, yes, that would substantially disadvantage disabled employees as they are more likely to take time off work, which obviously does make sense. However, the Court of Appeal then did say that the DWP had not failed to make reasonable adjustments because they were entitled to conclude that neither of the steps identified by the employee were actually reasonable for them to have taken. She'd argued that her 62-day absence should be disregarded because this was when her condition was diagnosed and her treatment put in place. However, it was concluded that the medical condition was not a one-off illness and that further absences were likely. In these circumstances, the tribunal and the Court of Appeal were entitled to conclude that it was not reasonable to expect the DWP to disregard such an extended period of absence. In relation to the fact that the consideration point should have been extended to longer than 8 days, it said there was no obvious period by which it should be extended. So, for example, if she had further long absences in the future, increasing that consideration point by a small amount would not remove the disadvantage suffered by the individual. She had 62 days absence. So if you moved it from 8 days to 12 days, it wouldn't have made any difference. But increasing it materially to cover that 62-day absence would effectively condone very extensive absence and almost make her impossible to manage. So it was found that actually it was not reasonable to expect the DWP to increase the consideration point in these circumstances. The court did go on to say that where an employee is likely to only have limited and occasional absences, then the position might be different. But in essence, you are not expected to disregard really long periods of absence as a reasonable adjustment. You need to consider, there are other reasonable adjustments that you may need to consider. Just lost where I am on the slides, I do apologise. So here we go. So in terms of reasonable adjustments, there have been a number of cases dealing with that duty to make reasonable adjustments and when that is triggered in the case of employees on long-term sickness leave. Another tribunal claim, I'm just full of them today, which is also a case in which the Department for Work and Pensions was involved. I'm spotting a theme. The EAT held, so the Employment Appeal Tribunal in that case, held that generally there must be an indication that an employee might be fit to return to work at some point for the duty to make reasonable adjustments to be triggered. This is because the employer's duty to make reasonable adjustments isn't aimed at helping the employee get better or to deal better with everyday life. That is not an employer's job to do that. Instead, the reasonable adjustments are about minimising the adverse impact of the disability in the workplace and to enable the disabled person to remain in or return to work with the employer and have a consistent attendance record. Frankly, we could do a whole session on this issue, but for today's purpose, we just want to flag to you that if an employee is on long-term sickness leave and they have a disability, or you suspect that they might have a disability, then the duty to make reasonable adjustments will be triggered if they do have a disability. If you're just not sure, you do want to treat it with an abundance of caution and think about any reasonable adjustments. And so as an employer, you may be required to take additional steps to ensure an employee can return to work or remain in work. So I think you've heard enough from me for a while, so I shall pass you back to Simi.
Thank you. Okay, so we now just wanted to deal with a few questions that we frequently get asked when dealing with sickness absence issues. The first question is, can we safely dismiss staff with poor attendance if they have less than 2 years service? Potentially, yes. Employees generally need 2 years service before they can bring an unfair dismissal claim. However, as we've mentioned throughout today's session, if an employee has a disability, then they can bring a disability discrimination claim under the Equality Act, and no qualifying period of service is required to bring such a claim. Employers should therefore be alive to the risk of such a claim, even if the employee has less than 2 years service. And you should also think about what message you're wanting to send if the company's position is that they simply dismiss employees without going through a fair procedure. It may be damaging from a wider employee relations perspective if you were to adopt such an approach on a regular basis. It's also good to be aware that if Labour goes ahead with its proposals, then employees may no longer need to be required to have 2 years service before they can bring an unfair dismissal claim. In the plan to make work pay, it talks about day one unfair dismissal rights, but it does seem to be reserving the right for employers to dismiss more easily during the probationary period. We don't know what that looks like yet, and we'll obviously have to wait and see what changes that means for employers. Another question we often get is what type of questions should be put to a medical practitioner when dealing with employees who are on long-term sick? In the case of long-term ill health, the company will usually be seeking to obtain information about the likely causes of absence, when the employee might be fit to return to work, and whether there are any adjustments or modifications that would assist the employee to return. It might also be appropriate to ask questions to help the company determine whether the employee is disabled for the purposes of the Equality Act. This could include whether there are any reasonable adjustments that they may need to make to facilitate their return to work. That being said, the fairly enlightened employer will usually consider adjustments for the merely ill too, without needing to be persuaded that the illness has crossed the line into a statutory disability. Now, a word of caution. The Court of Appeal in Gallup and Newport City Council, a case from 2013, made it clear that employers should not rely unquestioningly on occupational health advice, especially if the opinion of the advisor is that the employee is not disabled. Employers should remember that they remain responsible for making the factual judgment as to whether an employee is disabled for the purposes of the legislation. Which is why, to ensure they make the right decision, it's important employers are asking the right questions of their medical advisors in the first place. On the issue of whether the employee is disabled, the company should not simply be asking in general terms, is X person disabled? It needs to be posing very specific, practical questions directed to the employee's particular circumstances and the definition of disability in the legislation. For example, does X have a mental impairment? If so, does that impairment have an adverse effect on their ability to carry out day-to-day activities? Is that effect long-term? How long do you consider the effect might last? In cases like this, we will often see employers attach job descriptions or a description of the role to help the medical advisor assess their capabilities against that role. Equally, the company should be asking specific questions about whether they're fit to carry out the role, what the likely timescale for recovery is, when the medical advisor anticipates that the employee may be fit to return, and which adjustments may be necessary. The company should provide any medical advisors with copies of relevant documents, which will include job descriptions and any other information about the daily requirements of the role which may be relevant. Another question we will often get asked as well, just off the back of this, is we've followed all of our process, but what do we do if the employee is simply refusing to cooperate with our attempts to refer them to occupational health? In such circumstances, it's important that the employer explains to the employee why it's seeking to obtain the medical advice about their illness, i.e. to support them, facilitate their return to work, understand what adjustments can be made for them. Ultimately, though, if an employee refuses to cooperate with the employer's requests, they should be warned in writing of the consequences of failing to comply. That might include no longer being entitled to company sick pay, if that's what the contract or policy says, and that the employer may ultimately be forced to make a decision based on the information available to it.
Thanks, Simi. So a question that we always get asked is, how long are we expected to keep an employee's job open? And unfortunately, there is no magic answer to this. What an employer should do will be a fact-specific question, and it will depend on the nature of the employee's job and the illness. So there is no magic time limit in the Equality Act, and so we will never be able to say, oh, it's safe to dismiss after X amount of time. It just doesn't work like that, unfortunately. And there is, you guessed it, another case which I'm going to sort of give you some brief details about, which was Dundee City Council. And the Court of Session identified following factors as to which were relevant when deciding how long an employer should keep an employee's job open for. First one being the availability of temporary cover and its costs. So if you are just covering their role and it isn't costing a huge amount of money, then arguably you should be keeping that job open for a little bit longer if it isn't causing too many, if it isn't causing issues for the business. The question of whether the employee has exhausted their sick pay. The administrative costs that might be incurred by keeping the employee on the books, and the size of the organisation. The bigger the organisation, the more a tribunal would expect to see the job being kept open for a longer period of time, because in theory you should be able to absorb the cost of doing so. But the important thing is, consider all of those factors, but the important thing is, to get to the dismissal stage, you need to have complied with all the steps outlined above and your policy. And if you do that, then you should be in a safe position to dismiss. So in terms of whether you can dismiss an employee if they are still in receipt of company sick pay, it doesn't necessarily render a dismissal unfair if somebody is still receiving company sick pay and you dismiss them. And it is one of the factors that the Employment Tribunal will take into account when determining the fairness or otherwise of a dismissal. From a contractual point of view, a court may, in theory, imply a term that the employer will not dismiss an employee on the grounds of illness whilst that employee is in receipt of company sick pay, because it does raise the inference, if you have, say, a 6-month company sick pay, it does raise the inference that the company is willing to wait and to burden that cost for a period of 6 months. So why would you dismiss during that period that they are in receipt of company sick pay? However, whether or not such a term will be implied will depend, amongst other things, on the express terms of the contract. So you'd want to potentially see something in your contract which says, even if you are in receipt of company sick pay, this does not prevent the company from terminating you. It will also look at what the parties attended at the time of entering into the contract. So we're not saying you can't dismiss if somebody's in receipt of company sick pay, but you do need to be mindful of what does that look like and why are you dismissing during that period of time. Another question we get asked a lot is, what if an employer decides to dismiss an employee while they are on sick leave, are they entitled to be paid during their notice period if they have already exhausted their entitlement to contractual and statutory sick pay? So this is a question we get asked a lot, and clients are all surprised by the answer, I think, because it ultimately depends on the amount of notice the company is required to give under the contract of employment. So as you know, there are statutory minimum notice periods, and these are set out in the Employment Rights Act, which provide that an employee is entitled to at least 1 week's notice per year of service, up to a maximum of 12 weeks. In the same legislation, it provides that if the company is required to give notice which is at least 1 week more than the employee's statutory notice entitlement, then it will not be obliged to pay the employee during their notice period. So, for example, if the employee has been working for 5 years, their statutory notice period would be 5 weeks. But if they are entitled to 3 months' notice under the contract, then they would not be entitled to be paid during the notice period. Now, just to be clear, that's only in relation to somebody being absent and not receiving sick pay. Please don't take this away and say, oh, we don't need to pay anyone in their notice period, because that's going to get me into an awful lot of trouble. Might get me some more work, but it will also get me into trouble. So it follows then, if the company is required to give notice which is less than 1 week than their statutory minimum notice entitlement, so if their contractual notice period is the same as the statutory notice period, then they are entitled to full pay during their notice period. I appreciate that is a bit confusing, and we have absolutely no idea why the difference in treatment is there and why the legislation is as it is. Whether it's to encourage employers to give longer notice periods, I don't know, but that is the law, and that's what it says in the legislation. So who are we to argue? Okay, so next slide. Contracts and policies. We have talked about this throughout this session, but it's just a reminder of changes you can make to your policies and contracts to ensure your business is in the strongest possible position to manage sickness absence effectively. So do make sure you have a robust absence management policy. It should be non-contractual, so you can depart from it when you need to. Not only should you have that policy in place, you should make sure that managers know that it is there and what their obligations are under it. There's no point in having a beautifully worded, robust policy if nobody is following it. So do make sure that managers are trained up on it and know how it works. Your policy should set clear examples about attending meetings, attending return to work meetings, and about contact during a period of absence, and about attending medical examinations and how they need to sort of cooperate. And that a failure to comply could impact their company sick pay. Look at your contracts as well. Do they give you sufficient flexibility in regards to sickness absence? If you do offer a company sick pay entitlement, is there somewhere in your contract which makes it clear that that entitlement is not received if they go off sick during disciplinary action or a redundancy process, etc. So have a look at those contracts, see what you need, do seek advice should you need to, and if you want somebody to review those documents to make sure that they do protect the business as far as possible, then do so. That actually does bring us to a close. There are a couple of questions, and I think actually we've covered most of them. But there was one I thought, actually, I will just cover that. This was it. This was about employees maybe showing a pattern of behaviour when it comes to absences. So maybe, I think the question specifically was, if somebody is absent, if uses up all of their company sick pay every year, and doesn't seem to be any underlying conditions, and there's a pattern there, you should be able to take some kind of action. What you would want to see is in your absence management policy, and when you're looking at what would potentially trigger further action, you would look at the number of absences in a rolling period, but you would also refer to any pattern of absence which causes any concern. And by that, I mean people who are always off sick on a Monday, or always take a day's sickness absence after a bank holiday weekend or after a holiday, and that shows a pattern of absences. And it's the same with if somebody coincidentally seems to be ill for the exact period of their company sick pay, and then they're back at work, and then as soon as it's they're off again. You can take action, but the best thing to do is to make sure that that is covered in your absence management policy. There are lots of other questions, and we just don't have time to go through them all, unfortunately. But as I say, do have a look out for the blogs that we're going to send out after this session, which we will look at those questions to see if there's anything that we can include in our blogs to answer those for you. So thank you so much for attending. And if you do have any questions about anything you have heard, we'd be delighted to hear from you. Our contact details are on the screen, and our pictures again, which is a treat for you. So thank you very much, everybody, and do enjoy the rest of your day.